Okay, so this Robert Kraft case is another one of these things that's just going to be snowballing and going on and on and on. Filings have occurred in court, initiated by the prosecutor's office, who's indicating and trying to get the court to hold the attorney for Robert Kraft, Mr. Spiro, in contempt of court, criminal contempt of court, and also for witness tampering with respect to exchanges that the defense lawyer had with one of the state's witness, a police officer, Kim Bark, who had testified. It gets really squirrely and strange, and then the defense has responded essentially saying the state is wrong, there was no witness tampering, there was no attempt to deceive the court, and all this is a Hail Mary pass, no pun intended, by the state for a case that they claim is going up in flames. Let's take a look at a little bit of that courtroom action between the attorney and the police officer before I go back to Gene and Ann, who I'm pretty confident are going to have a lot to say about it. Okay, so we also have a statement from the attorney in this case with regard to these motions that are filed. I believe will be coming up on our screen soon, and it says they know what they filed is false, that's referring to the prosecution, and misleading to the court, but they did it anyway because they are desperate. That's because they want to deflect attention away from their illegal and unconstitutional methods in investigating and prosecuting this case. That's from William Burke, B-U-R-C-K, attorney for Robert Kraft. Okay, Ann Bremner, I know you've been following this. Is this a legitimate thing? They're saying that the prosecution, that he made up this idea, that he made a comment, the police officer, that he was going to make some up, okay, expletive with regard to the stop. It didn't really come off that way to me when the lawyer was asking the police officer those questions. Give me your thoughts about that first.
Basis to ask that kind of a question, then you can ask it as cross-examination. And you know, the officer wasn't unequivocal, you know, in terms of a denial. And you know, think about this too. I mean, for both of you so experienced, you know, as trial lawyers, how often do you see a motion for contempt? Really, I mean, how often do you see the prosecution move to have a lawyer held in contempt? Not very often, at least. Not out here on the West Coast. Well,
Gene, let's pick up on Ann's point there, because I think it's a really good one. As a prosecutor, we've talked about this before, you've got to play chess, not checkers. And my question becomes, does this poison the well even more? Did the prosecutor jump at the bait? Are they doing something that is, in fact, desperate? And is the judge inclined to really listen to this? Is there any merit to it?
I think the judge is going to just ignore these motions. He's going to deny the motion for contempt. And here's my gut reaction. If Alex Spiro did not have good faith, assuming he did not, okay, you don't file a motion. I would just bring it to the court's attention, let the judge admonish Spiro, say next time be very careful. I think you kind of got close to the line there, but it's not the basis for a motion for contempt. And I agree with Bill Burke's and Alex Spiro's response and opposition. This is a Hail Mary pass. It's a shiny object, and it's a shiny object to distract from the core problem. Minimization is awful in this case.
Right, right. And let's go to another aspect of this motion, which is some encounter that occurred between the attorney and that police officer that we saw in that clip. Describe for our audience what went on in that encounter where the prosecution's now alleging that the attorney was attempting to intimidate a witness and interfere with their prosecution.
Well, you have to keep in mind I read these on my phone, so in the last few hours. But it basically was, there's a rule of sequestering witnesses, and that means you don't talk to them because you don't want to influence them, and that there was some kind of a threat made to this officer that violates the order of the court of sequestering witnesses and an attempt to intimidate a witness, which could be tampering, and they've alleged tampering with the witness, which is a felony.
Yeah, I think we have a statement from the officer with respect to that. Yeah, there it is. The Kraft video suppression is the title. And quote, Spiro stated, I have a video of you saying stupid S blank, 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 expletive. His facial expressions as he smirked and his raised eyebrows, along with accusing statement, intimidated me to believe I had done something wrong. That's from Officer Scott Kimbark of the Jupiter Police Department. So, I mean, Gene, let me go to this. There was an encounter that occurs outside the courtroom. Now, the lawyer says this started because the police officer came up to me and asked me whether I was released. There's also information in this motion that the lawyer said, and I'm surprised it wasn't contained in the statement that we just read, that the lawyer said that if they don't call another one of the police officers, he may not have to use this secret piece of evidence that he has that would be somewhat embarrassing. Look, I think the judge is going to shelve this too. I just think the defense lawyer put himself in a really bad spot with that.
Oh, I agree. I have a high respect for Alex Spiro, and this is just stuff that happens in the hallway all the time. And you experienced it, Bob, you experienced it. Stuff happens in the hallway that you're embarrassed to even talk about. It's just a high-octane case. It's not the basis for a motion for contempt.
What are your thoughts about the out-of-court encounter in the hallway, Ann?
Well, I mean, it's not pretty, and the fact is, if you have, I mean, the whole rule on sequestering witnesses, we know, is so they don't, mirror their testimony or shape their testimony based on what other people say. Does it really mean you can't talk to them at all in the hallway and say something, that's relatively benign? Just to do this whole thing about, I've got you on tape saying stupid, S whatever. I mean, that does feel intimidating a little bit. And does he have that kind of a tape? And is it this whole thing of I'll make it up when I see him? That's the alleged statement that was attributed to this officer about kind of pretext stops. But then on the other hand, there's certainly some ugly encounters in hallways. I mean, I've had them. I try to ignore people. I certainly don't go after witnesses because I'm an officer of the court. I mean, we'd all be the same way. But, these things can happen.
Well, I got to say, and this is a teachable moment, guys. As a lawyer, I don't approach my adversary's witnesses. I don't do it unless that lawyer is present. And especially, and I'll be very interested to know your guys' point of view because you come from different jurisdictions. You could be potentially making yourself a witness by approaching somebody and having a conversation without a third party present. Gene, what are your thoughts about that?
I never talk to a potential witness, period, without somebody else next to me. Never did it.
How about you, Ann?
Same thing. I was going to say, great minds think alike. I always have someone with me. I have a paralegal when I was a prosecutor, police officer. I mean, it's so important. You don't want to become a witness. You also don't want to be, alleged to have done things like we're seeing right here.
I was just going to say, Ann, you know what at a minimum having a witness there does? It prevents something like this document that's being filed against you, asking a judge for criminal contempt and that you tampered with the witness. Gotta play chess, not checkers. And thank you so much. Gene, thank you so much. Always great analysis. You'll be back when we're going to take a real quick break with more Law and Crime on the other end.